promotes professional standards, education, training, and ethical practice in alternative dispute resolution. And as you'll see today, it also encourages international networking, including through its various branches and chapters, inclusive of the Uganda chapter. The Center for Law and Emerging Technologies is a research and policy initiative that was started at Makerere University. It focuses on the interaction of law, technology, and society, and particularly the effects or the legal and regulatory implications of emerging technologies. And we are glad that today we will be hosting its convener, Dr. Robert Chirunda. My name is Mr. Victor Ntamgavumwe, and I will be your moderator today. Our speakers are two, Dr. Robert Chirunda and Mr. Simon Semaganda. Dr. Robert Chirunda is an advocate of the courts of judicature in Uganda and is an arbitrator. He has training with the Chartered Institute of Arbitrators and is empaneled on various arbitral institutions. He has an impeccable record, as for those in Uganda are aware, in litigating very high-value commercial disputes, which have shaped the economy of Uganda today. He has also advised on national policy formulation, specifically regarding the place of law in the ever-evolving technological space. Our second speaker is Mr. Simon Semaganda. He's a practicing advocate of the Court of Judicature of Uganda, and he is currently serving as the head of litigation at the National Social Security Fund, or what we call NSSF. Mr. Simon Semaganda has over 10 years of experience in litigation and dispute resolution. And we are happy to have him today. Dr. Robert Chirunda, would you mind saying hi to our participants, just briefly?
Thank you very, very much, Victor. Good afternoon to my colleague Simon and everyone on the call. Thank you very, very much for taking off your Friday afternoon to join us. We're looking forward to what we believe will be a stimulating and worthwhile conversation. I'm also grateful deeply and profoundly to the CIAB Uganda chapter leadership for convening us today. And yes, let's have a good discussion. Thank you.
Mr. Samaganda, just a brief hi to our participants.
Thank you very much, Victor, and hello, Dr. Chirunda. Hello, our participants. Just maybe some brief correction to you, Victor. I am not the head of litigation at NSSF, but I'm in-house legal counsel. So for avoidance of doubt, I don't want to assume a role I don't have. Thank you very much.
Okay. Today's theme is AI regulation and ethical standards for practice in arbitration. And it's quite a hot topic out there, the place of AI in arbitral proceedings. And as you well know, it does affect the handling of proceedings, right from appointing of arbitrators to handling of the proceedings, evaluating evidence, understanding the facts, and ultimately it may have an influence on research during the arbitral proceedings, perhaps when arbitrators are making the decisions. And as arbitration has been for over time, it has been one of the practices that actually adopts innovation in technology. And as such, that's metamorphosed. People don't need to travel abroad, for instance, to participate in arbitral proceedings. People can actually have arbitral proceedings over online platforms. So for today, Dr. Robert Chirunda, why is AI, what is AI specifically, and why is its regulation necessary? So that our participants can have a brief of what actually AI is.
So thank you very much, Victor. I think this is a good place to start. Now, I am going to propose to define AI from a technical and a non-technical perspective. So in very, very simple terms, AI is this new tool that attempts to codify what makes human beings the most special species on Earth, which is intelligence, and basically trying to get computers to do what humans can do in very, very simple terms. And you do that by building a network and a tool that imitates the human brain. But we are lawyers, so perhaps a more technical definition is helpful. And since this is about regulation, the clearest and perhaps most ambitious definition is in the EU AI Act, which defines an AI system as a machine-based system that operates with varying levels of autonomy, may adapt after deployment, and here is the operative phrase, infers from the input it receives how to generate outputs such as predictions, content, recommendations, decisions, or even images. Now, the crucial word there is infers. It does not follow rules that someone wrote. It derives from its own data. And the three properties one can take out of that definition are basically that it infers rather than obeys. In other words, when a system produces an outcome, no human can claim authorship out of it, technically speaking. It is probabilistic and not deterministic. Basically, it predicts which word comes after another. When we were in secondary school and they were teaching us how to write good grammar, they made us fill in the blanks or rewrite sentences. Really, AI does a similar exercise only from a mathematical perspective. And that's why we say it's probabilistic. It's following probabilities, not deterministic. What we used to do was determine. And the third is that it's opaque, but it is not secret. It's opaque in the sense that even the people who built the system cannot state exactly why it produces a particular output. And we'll come back to this later. It is the so-called black box effect. Now, that's generally speaking how you would define it. And a good example is to use, as I said, when we were doing English in senior 1, senior 2, you remember you write this sentence beginning with, well, I don't know if that was primary or A level. Also, I realized that there may be people in this school who went to international school and things they are done differently. But if you had to rewrite a sentence and to fill in a missing word, you were basically being deterministic in how you answer that question. AI is more mathematical. Now, regulation is necessary for maybe 4 or 5 reasons. One, scale. A human decision maker who misapplies the principle affects the outcome. That's so across every result it will give you. The second is the fact that, as I said, no one can really explain how it arrives at the things it does. Now, that opacity defeats accountability. And every accountability doctrine that we know requires that you ought to have known. So we as individuals, for instance, if you think about the way we argue law, every time we file a defense, we are mitigating that which the law is saying to us, you ought to have known. Take the example of Donoghue v. Stevenson, that my neighbor is a person who reasonably would have been affected by my actions. Now, that accountability framework, that's an accountability framework, but yet with AI, the opacity of it defeats that idea. So the duty to give reasons, open access to judicial review. In the course of that, we are subject to test my accuser by cross-examining them. In civil matters, I test my evidence by cross-examining the person who's giving it. In the AI context right now, there's really no way to go past that opacity because there's no way to hold these tools accountable. And then you have the fact that there's a lot of fusion of responsibility. Of course, people say the short answer is hold the owner of the tool accountable, whoever built ChatGPT. But that, you see, there's a fusion between the developer, the deployer, the user, and the institution that produced the tools. So who do you hold accountable for what? because the developer is not necessarily the person who deployed the tool. The person who deployed the tool is not necessarily the person that built it or developed it. So one needs to be able to allocate the duties and responsibilities correctly, and that's what the regulation would answer. And the fourth reason for regulation is what I would refer to as asymmetry. And that asymmetry is the fact that arises from the fact that the person affected by the decision or by an AI-influenced decision or action cannot detect what AI was used, or sometimes they may not even know that AI was used. Think about a judge who is reading submissions. All they see is a case. And that case basically is you're telling them in Mutambulire versus Chimera, the High Court said. Now, if it turns out the case of Mutambulire versus Chimera doesn't exist, the High Court judge would not have a way of knowing that. So they must then decide, you misled me because you gave me a case that doesn't exist. How do I hold you accountable? Right? So if you think about those, I would argue that those are some of the reasons why regulation is important. Now, there's another counterintuitive reason. Regulation actually, in some ways, is what unlocks adoption, not what blocks it. People have argued that, you see, when you regulate, you stifle innovation. That argument is true to an extent. It is not necessarily always true. Recent studies show that, for instance, White and Case did a survey in 2025, and that survey disclosed that of 2,402 respondents, which is so far the biggest survey in our space on this question, 38% of the respondents named absence of clear regulation or regulatory guidelines as an obstacle to using AI. Now, what that really means is that there are people there who are saying, if you regulate, then I know where my parameters of liability fall, therefore I can use. But if you don't, I am uncertain. So practitioners will then not adopt the tools because they can't tell a client whether or not its use is permissible. And we'll talk about this again in arbitration, how you go about it. But if you bring it back home to Uganda, the absence of a specific regulation is also now notably one of the issues affecting literacy in terms of how do we use AI, how do we learn about it. So in simple terms, Victor, why is regulation necessary? We regulate because rights are meaningless without a duty bearer, and at the moment there's no one. I was speaking to some people recently, and I said to them, every policy framework answers 3 questions. If there is a wrong, who is accountable? Who makes the decision? How do I hold them accountable? And if they are wrong, how do I enforce the accountability framework? So we don't regulate technology because we fear it. We regulate it because we want to provide an accountability framework. I think I'll leave it at that for now. Thank you.
Thank you, Doctor. And I think for the session, a few words that should keep in the minds of the participants. It infers and does not follow the rules. It's probabilistic and it's not deterministic. And bringing it to the theme, Mr. Semaganda, why is the conversation on AI and specifically to arbitration, why is it important?
Thank you very much, Victor, and thank you very much, Dr. Chirunda. You have laid a very good foundation for our webinar discussion today. So to answer your question, Victor, I think this conversation is necessary because it's no longer a question of whether artificial intelligence will be used in litigation, arbitration, or any dispute resolution mechanism. It is a reality that it's being used. Now, the real question is, how can we use AI professionally, responsibly, without undermining the very qualities that constitute this dispute resolution mechanism, specifically arbitration? Because when you look at arbitration, people come to arbitration because of the fairness that they expect the process to give, confidentiality, party autonomy, independence, procedural equality, issues of enforceability of the award. So those are very key. So we acknowledge that AI is capable of helping lawyers and arbitrators with research, document review, summarizing large documents. Probably sometimes some lawyers use it to draft their pleadings that are going to be submitted. So we recognize that AI plays a very critical role. So we are discussing the aspect of regulation at a very critical time because we need to shape the way how AI shall be used. We acknowledge that there is both responsible use of AI and irresponsible or misuse of AI. And just like Dr. Shunda has pointed out the research done by White and Case, as well as Queen Mary University, specifically on that area. And we also note that some arbitral institutions have already gone a step ahead to introduce matters concerning AI arbitration, where the be generated or made. American Arbitration Association. In the end, you realize that even in that case, you have a human having a role to play in reviewing the decisions and does not circumvent the very purpose of arbitration and why parties come to it. So you realize that it's critical to have these discussions because of the very many risks that the use of AI can present. We recognize the benefits as well as we have to be mindful of the risks, because once we do not take advantage of these challenges and address them, then the system can affect the entire process of arbitration. So it's important, to answer your question, for us to have these conversations now such that we deal with the very fears that arise when there is a disruption like AI has done in our space, and then put in place guidelines that are going to put in place or promote the responsible use of AI. So Victor, that is the simple answer to your question.
Thank you, Mr. Samaganda. Now, Dr. Shirunda, in the arbitral process, from the beginning to the end, what are some of the critical use cases that we've seen where AI has been used or employed in the process?
So Victor, I'm going to try and answer this question through a tiered approach, right? I'm going to try and break down the process rather than give you 1, 2, 3, 4 cases. What I propose to do is to propose some cases alongside 4 tiers. And if you think about an arbitration process, think about the process as a spectrum, right? And from the time I draft my clause to the time I enforce my award, if you see that as a spectrum, then we then start to think about what is being used where, and you realize that where the use case sits, I want to blend in a few other thoughts along with the question. So at tier 1, I would talk about the uses that no one objects to. So I'm going to try and combine use with ethics. There are those elements of the arbitration process where use is not in dispute. Everyone agrees you can use that if you want. And that is, for instance, in the context of transcription and real-time hearings. So I have drafted my clause. I have declared a dispute. I have gone to arbitration. Now, as an arbitrator, when I am hearing the parties, I need to do what we used to do in the courts when some of us started practice, which was record everything as closely as possible. Then we began to use our phones to record and make an audio recording. But now there are tools that enable us to, once I turn it on, I just follow the proceedings and let it generate a transcript. For some people, when you turned on your Zoom this afternoon, it said, by the way, the Zoom note taker is on, and you agreed. So you will get a transcript of this call when it is done. There you have Opus 2, you have Verbit, and some of the tools out there that are being used. Now, machine translation of exhibits is also another space in what I would call tier one. These ones people rarely object to because just reproducing information in a different way. You're taking it from audio to written. So there's really no analysis there. And you have Bando and Konoja preparation. If you were doing the CAB course, you probably would have come across Red Fan, organizing your Bando in Red Fan formats and things like that. That can also be done by AI. Then you have entity extraction. You have automated timelines. You have scheduling and case management. And you have technology-assisted document review, which predates generative AI and is also court sanctioned in several jurisdictions. As I've mentioned there, you have players like Opus, Verbit, then you have Relativity AIR, you have Everlow, you have Disco, you have Luminance. Incidentally, Luminance was backed by one of the biggest law firms in London, Slaughter and May. And now I believe Bowman's in South Africa has announced another tool. I'm trying to remember the name, which they are using and sort of initially was developed in-house by lawyers. And so adoption here is already majority in practice. So at least 50, you will find some studies saying at least 59% of the people who are using these tools in AI have used them for document review. 90% expect to within 5 years. Now, at tier one, which is basically a routine process. Tier two is where you now start to get into research, legal and factual research. These ones are tools that are established but require care. And the highest adoption category, which is where the adoption is moving fastest, where you now start to go into research to analyze a document. So research can be something as simple as I receive a claim as an arbitrator and I tell a tool, tell me, here is the claim, here is the law applicable, tell me what the issues are. So as opposed to tier one where the issue was reproduce information, now we start to engage to process information. And in this category, as I've said, this is where the fastest adoption is happening. In the field of arbitration, you have arbitration-specific engines like UseMundi, whose use AI research agent. They launched in September last year, and that one is purely AI-based. And then you have those which are not really announced as AI-specific, but which are agent-to-agent integration. And here you're basically saying, I have a tool that was built for other purposes, but I can repurpose it and I can match it with the tool that I'm using in AI. Here you have matching of tools, but then you also have the more generic, where I basically use a tool that I use for everything else, but I can repurpose it. The commonest in the third category I've mentioned are Harvey, Legora, CoCounsel. Harvey is, I think, was the first purely legal AI startup to announce that they were going to build tools. You also have, in this category, I would add the tools built by LexisNexis. The AI platform for LexisNexis is actually quite active, and in some markets it's doing really well. Now, there you may also want to go into things like cost budgeting, first drafts of correspondence, transcript analysis, inconsistencies in testimony. They can be very useful. If you imagine, I participated in an international arbitration once where one witness testified for 2 days, and the transcript for day one was 100 pages. The transcript for day two was 90 pages. So you have one witness and you have 190 pages. You can do it the good old way, read with a pen, underline, or you can ask a tool, summarize for me, do for me and the issues and map, give me a table that says what he has said about every issue. and what came up in cross, and that analysis will typically be faster if you're using AI. And then you have what I would call tier 3, which is again where you have, this is where adoption is a bit contested. But what are you doing in tier 3? You're basically now taking analysis to another level and you're saying, draft for me. And the sharpest adoption gradient in recent surveys I have seen falls here. 72% of arbitration practitioners in one study had never done it. In another study, but 66% of those 72 expect to do it. So I think you can see where we are sliding up a curve, right? We began by just transferring information from one perspective to another. Now we went to, okay, summarize for me. Now we are analyzing. And if you think about the arbitration process as a spectrum, you can see where all of this is happening and how it is moving from one area, from one stage of the process to another. By the time you're analyzing or you're drafting submissions, you finish the evidence. A cautionary note here, though, arbitrator intelligence, which is the flagship of independence of an arbitrator, is the one thing that will be the most contested thing, and we must keep in mind. Counsel can use a tool to summarize. Counsel can use a tool to draft. It remains a contested issue, and we'll talk about it later, I believe, as to whether an arbitrator should use a tool to draft an award. And what process goes into that. Now, the last one, which I would call tier 4, is the questions around the award itself, which I started to talk about just now. This is a very interesting one because there are those who are saying, no. Of course, the award must be owned by the arbitrator. So this question goes into, and I don't mean to preempt later discussions, but there are use cases of where they're saying an arbitrator's role, there are things they can do. So an AI native arbitrator, and yet on the other hand, you have AAA in the US, which launched an AI native arbitrator, which is basically processing all this information through the computer and not even having a human in the loop, as the AI practitioners would say. So the role of at tier 4, you have AI assisted processes, and then you have AI drafted, and that's where the question is. So in simple terms, Victor and colleagues, almost every use I have described is something that an arbitration lawyer can use AI for. And over the last 5 years or so, adoption has happened from initially starting from software. As I mentioned, transcribing used to be, there were tools that didn't involve AI, just that AI tools now can respond to more accents, more languages, and perhaps work even faster. But the moment you cross from doing a manual task to doing a task that involves reasoning, summarize for me, because there's a judgment call there. Is the summary good enough? That's different from transcribe for me. The moment you cross the reasoning barrier, you have entered an AI use case. And some of the players, as I mentioned, are CoCounsel, Opus, Fabit, and there are so many. Literally every month, there's a new player doing something. But what I have found is that in all the demo days I've attended, or the demo platforms I've attended, is that when you group all these players, they fall in these 4 categories. There's tools for cost control, especially in construction. There's tools that now go into analyzing, for instance, technical construction documents, drawings, and whatnot. And then there are traditional tools in which they're embedding AI. So for instance, construction practitioners would be familiar with BIMs. Now there's discussions about whether or not you want to integrate BIMs into AI. So you have AI external processes that are now integrating, and that's why I talked about agent to agent. But Victor, I hope that gives colleagues a general layout of what the land looks like today. Thank you.
Yes, I think it was quite elaborate, and there's so many things that I think you can use AI for in that process. Mr. Simon Semaganda, I think the question then really is, what are the pitfalls? What are the risks that we run either as counsel or arbitrators as we employ AI in the use cases that Dr. Chirunda has mentioned?
Thank you very much, Victor, and thank you, Dr. Chirunda. The pitfalls, in our discussion, we have been hinting on some of them. Some have come through Doctor's response to your last question. But I would love to categorize these risks in around 7 practical groups. The first group I speak about is about hallucination and accuracy. There's always a challenge involved with using AI that sometimes it can give you a very convincing answer. So there is a case that was handed down by the Superior Court of Quebec this very year. And in that case, the Superior Court of Quebec annulled an arbitral award because the sole arbitrator in that case completely relied on fabricated AI-generated legal reasoning and citations. So you see in this case that much as we have identified what AI can help us do, summarize, help us do research, help us look at a voluminous document and give us a one-page summary, it comes with that risk. And sometimes when you involve it in giving you a reason for a decision, it can be biased. And being biased, it creates facts that do not exist. Like Dr. Chirunda alluded to earlier when he gave you the case of Mutembulile. You could have a case that is not existing, relied on by counsel. So what does that mean? It means that as counsel, when you're relying on AI-generated research, you should simply not copy whatever you have received into your submissions. If you are doing it that way, you should avoid entirely leaving the submissions to AI. Be involved. If you choose to have AI do a part, maybe it's giving you the draft 0. You can't simply submit draft 0. You need to proofread and confirm that the information you're relying on is accurate. The other pitfall that we identify or the risk is about confidentiality and data protection. And this is the most critical because you realize that many parties choose arbitration as the dispute resolution mechanism because it's going to offer the parties the confidentiality they seek. That if MTN is having a case against Airtel, they will probably want to have that matter handled confidentially and confidentiality being a key in that particular aspect. So when you upload information on these AI generative tools, you'll ask yourself a question. Who is in control of the information that I'm putting on the tool? Do you understand what happens with the information after you have given it to the AI tool? What is the level of exposure? So it's a risk because you could see that doing that may help you in one way, that is, do the work faster. However, by doing that, you have exposed the parties to the violation of confidentiality and protection of their data. So as counsel or as an arbitrator, when you're doing that, you have to be mindful of the risk associated with using such tools. Then also in that category, similar to it, we'll have what we call cybersecurity and data integrity. And it's closely connected to confidentiality. So arbitration has become digitally heavy, that most of the things we rely on pleadings, witness statement, expert reports, and all correspondences are now in electronic form. They are on a computer somewhere, they're on a drive somewhere, they're on the cloud. So they are accessible by third parties who could probably hack. But now if you are using AI and AI is holding this data in its system, how do you know that there will not be a vulnerability to your client as well as to the parties that have come to use this process? Then the other thing that we need to think about is about bias, independence, and impartiality. Now, we noted from what Dr. Chirunda laid out in the beginning, how these tools work. you realize that they are trained by humans. They are trained on human data. And you have seen in many of the tools, as they are doing revisions and updating them, they are making them better, they're improving them and stopping them to use certain words because they had been trained on certain data that is having also that has been fed with information that is biased towards a particular thinking. It may not give you the best, even if you present it with the information you have. It may respond to you based on the data it's holding rather than on the crux of the case. So just imagine a situation where an arbitrator is deciding a matter that is pertinent to the parties, but the AI they are using is only having information or access to data skewed to a particular thinking only. It has only been fed information where in a particular case, the judges decided in a particular way. So you find that it will give a decision that is embedded in bias and lack of independence, and probably you'll argue impartiality. And these are critical things when it comes to arbitration, because a decision in arbitration will be upheld, respected, if it has been arrived at with the independence that the process expects, as well as the impartiality that it's supposed to be. Then there's another thing that we need to think about as well, due process and equality. You note that from what we are discussing, there are lawyers or parties that have access to AI, and then those that do not have access to AI. So suppose one party has access to sophisticated AI capable analyzing tools that cost a lot of money, maybe internally generated by that particular firm or by that particular entity, and the other party does not. So that technological asymmetry can affect procedural equality. Someone can argue, but isn't it the same case if I hire a top lawyer and you hire a junior lawyer fresh from campus, creating balance where you are relying on a system that is creating unfairness in the process. And if you are to flip and put it on the side of the decision maker, the arbitrator, what will the implication be? How are we going to look at this, where the arbitrator is using systems that the parties did not have access to or did not consent to, which we shall look at later, and they are generating information, which information they are relying on to decide the case as they have decided. We know that in arbitration, arbitrators are encouraged to make decisions on matters that were brought before them and on issues that were submitted before them by the parties. So what happens where in this process, the AI tool is presenting issues probably that the parties didn't address, and that becomes a very critical problem. The sixth category, which Dr. Chirunda pointed out in his earlier discussions, is about the black box problem, the transparency. You say the process is opaque. You can't really see what you can find out, but you can't really see where the input versus the output. The same way you read a judicial decision and see that this is how the law has been applied. Then you can question whether the judge's application of that law is thorough and proper in accordance to no judicial standard and practice, or they have not followed the expected apply to that. In some cases where AI has been used, you'll find that, yes, it may point you here and there, but you don't have clear visibility of how this has been done and how that decision has been arrived at. Then finally, number 7, which is the core of all these pitfalls, is delegation of professional or adjudicative responsibility. And that means that when parties come to an arbitrator, they're coming to a natural human being. They're expecting to get a decision from the arbitrator. So if the arbitrator is to delegate this function and responsibility to an AI system, what does the law, what is the practice, and what are the rules saying about that? Is it lawful that you came to a particular arbitrator Dr. Chirunda, a particular arbitrator, Semaganda or Victor, to give you a decision on a matter, and then you find out that this decision was not made by that person, but rather a tool. Now, there are questions around that. What if the decision is the decision in favor of what I want? Should I just be happy and go forward? It calls in the issue of ethical standards in that regard, that just because AI has given you a decision and it's in your favor, is it okay because it's in your favor? So what happens to the other party who did not get that opportunity to get the decision in their favor? So the use of AI is important, and it's with us today. We can't run away from it. However, it's important for us to realize the risks. Now, when you look at the CIAB guidelines, they call upon the parties or the participants in the arbitration process who are using AI to use it responsibly. They do not stop you. I would say they are technology neutral. They do not stop you from using. They do not prohibit you. However, they say use it responsibly, know which AI tool you are trying to use, what are the risks associated, have a risk benefit analysis. What is the risk involved versus the benefit I'm going to get out of it? And this also applies to the parties, because in terms of this area of discussion, we tend to focus so much on counsel and arbitrator. But we are seeing cases where before even parties come to you as counsel, they have already submitted their decision, their disputes per se, and documentation associated to them in AI. I have had cases where a colleague has come to consult me at work, and they are consulting you, but they have already submitted their query in AI. And after I have given your position, they reveal to you how AI gave a better reasoning or agreed with you on a particular matter. So there are so many things associated with that, which even we need to guide parties on, because issues of confidentiality may be violated, but not by counsel and arbitrator, by the party itself. Thank you very much.
Thank you, Mr. Semagan. And you touched on a critical issue, the opaqueness, and on how actually AI comes with, comes up to a decision or a solution. And that is what earlier Dr. Chirunda had mentioned as the famous black box. Dr. Chirunda, we've seen autonomous arbitration. And like Mr. Simon has mentioned, the opaqueness is something that you really need to be thinking about as you use AI. What about autonomous arbitration? How is it working? Do they give reasons when they give that decision?
There's this AI agent that keeps hiding the unmute function from me. I'm just being silly. So let's talk about autonomous arbitration for a second, right? When you think about autonomy, you want to think about it from two perspectives. I was speaking at an engagement earlier this morning where we dealt with the fact that my colleague who spoke before me said, let us remember that intelligence comes from human beings, but we don't qualify it as human intelligence. We just presume it is intelligence because it comes from human beings. Now, because what comes from AI is artificial, we therefore say artificial intelligence, right? Now, that's a useful thing in the context of the starting point of every validity of the validity of every step of the process is party autonomy, right? Now, therefore, I would suggest we don't jump straight to autonomous arbitration while discounting party autonomy, because one is the basis for the other. And then you come to what is happening at the AAA, for instance. And Yusmundi is building or has built a platform like this, where people say, let us have a process that minimizes human involvement. I like giving the example of Standard and Chartered. A few years ago, Standard and Chartered made a decision to close its branches in Uganda. To make that decision, they started from a different perspective. They said, how many human beings does a client interact with from the point they walk to a bank, to a branch of a bank? Let's say you walk to Speak Road, and before the security guard pats you down, from the point where he pats you down, how many people do you interact with until you leave? Yeah, the guy pats you down, then you go from there, you walk in, don't know what to do, and a customer care agent tells you what you want. I want to check my account balance. Okay, fill out that slip, take it to that person. Oh, okay, now I want to withdraw. Okay, fill out that document, take it to the till. Okay, but it's a lot of money. Okay, you go to the next stage where there's a human involved at every stage. Once they said, okay, how do we remove all these people? We put automated digital ATMs. But what about the security guard? CCTV camera. How do you make sure they don't demolish it, put it too high in the room? That process is what they went through. With automated arbitration, what has happened is people have said, wait a minute, what if instead of having an arbitrator like Mr. Semaganda, they simply say, no. Let us use a tool. So what happens is you will pay to the center, you go to ICAMEC and pay X amount. Then step 2, you opt into the use of their tools. And then step 3, the entire process runs ideally without first meeting of the arbitrator, second meeting, procedure order this, procedure order that, and it's automated all the way. There are things that are worth highlighting. Number one, the main difference between automated arbitration and what we do on a daily basis today in Uganda is that one is human-centered, the other is not. Number 2, party autonomy remains crucial to both processes. Number 3, at the end of the day, you chose to go into that process. So you can't complain about its pitfalls. Now, and incidentally, going back to what Mr. Samaganda so eloquently dealt with, if I could just add to that while discussing this point. If you look at section 31, subsection 6 of our Act, that provision says that the arbitrator shall, which we understand to be mandatory, state the reasons upon which the tribunal shall state upon which it based its decision. Now, the law says the reason, not any number of reasons. Why did you decide the way that you did? That is probably, in my view, the best explanation of why the black box problem is crucial in arbitration and why the question of setting aside an award, because it was rendered by an arbitration tool, is critical. A judge sitting and deciding whether or not to set aside the award is going to start by saying, did you pass the procedural tests? Yes. Did you make this decision? Yes. Where were you seated when you made the decision? In Kampala. Is that the seat of the arbitration? Yes. Okay. What were your reasons, or what was the reason you based upon the actual reason? It is this. When you choose an automated arbitration for yourself or for your client, what you are doing is you're subjecting the arbitration to a process within which this specific reason is difficult to find. Because, like I said, these tools are probabilistic, they are not deterministic. They base on mathematics, they don't base on proper in human intellectual assessment. So That, in a manner of speaking, Victor, is how I would suggest to answer. Now, obviously, what has happened in between is that you have like when I sit in arbitration now, in the first meeting of the arbitrators, I make it a substantive agenda item for the parties to reach a position on the use of AI. Where parties say, yes, we want to use some, and I stagger the question. Number one, should we use AI? Yes. Number two, should we disclose what we used it for? Yes. Number three, should the arbitrator use AI? What I have seen is that parties will sometimes say, as parties we can use, we don't need to disclose. But you as an, I've seen that in an actual live arbitration. And that is not an automated arbitration. Well, automated is what is happening at AAA and USMUNDI have said, no. We can simplify and even quicken the process. And I'll use another example. Think about the major shopping platforms that some of us or some of the attendees on this call use. Think about Alibaba, think about Amazon, think about what's the other one? Think about PayPal, the payment engine. By 2024, the PayPal payment engine was processing 56,000 disputes a year. Now, I don't know what the number is. If someone could pull it up and drop it in the chat, would be grateful. But I think Uganda's entire judiciary backlog, you know this thing we call backlog, which we've been stressing and fussing over? Uganda's entire judiciary backlog is maybe 110,000 cases across the country. Now, if one company has an engine that can process, and I think the number would be higher now, as many as 56,000 disputes in a year, do you realistically think that a human being sat there and read 56,000 claims and made a decision? No. So what's happening here is you go onto the PayPal engine and you say, I have a problem, my money was deducted, I want it paid back. And some algorithm decides, yeah, what are your facts? Yes, no, goodbye. I would actually argue the same thing about Airbnb. If you've used an Airbnb in some cities in the world, what's going to happen is that the host is going to come and say, you stained my rug. This is a rug made out of Iranian cotton. It cost me, therefore I needed to pay $700 extra to replace the rug. And then the thing is going to say, yeah, respond. You have 12 hours. You're going to respond and say, it is not possible because when I left, the host was there and the host said nothing. Aha. Then they say, okay, we have heard you. We have conferred with the host. Don't pay. My honest suspicion, I don't have evidence on this, so don't hold my, purely because of the speed at which the answer comes back to the client are made by AI. Now, that is your typical automated arbitration process where there's no human involved, there's no human in the loop. And yet, in the ordinary process, the human is the loop. I am the loop between the claimant and the respondent. They're talking to each other through me, and then I decide, okay, you're right, you're wrong. In automated, remove the human from the loop. Go through the process, get a decision. That's the difference. Thank you, Victor.
Thank you, Dr. Chirunda. That's it's quite an explanation. And earlier, Doctor, you also mentioned that some of the principles that we should look out for in regulating AI usage in arbitration is oftentimes where does the liability fall? We've talked about opaqueness and the fact that you must actually give a reason under the ACA. Mr. Semaganda, where would we place regulation in Uganda's statutes or the laws today? Should we amend Section 34 of the ACA in as far as setting aside an arbitral award, or can we go ahead and do some other regulation?
Okay, thank you very much, Victor, for the question. Yes, if your question is, should Uganda regulate AI use in Uganda? My direct answer is yes. Specifically speaking about Section 34, or whether we should amend it to repurpose it to focus on AI, the use of AI in arbitration. My answer is I don't think it's necessary, not necessarily that we should do that. Now, to answer your question more broadly, I would think that it's important for us as Uganda to have clear guidelines on how AI should be used. And just like Dr. Chunda pointed out that having guidelines or regulations does not necessarily mean that we are going to stifle innovation. Actually, we may further and progress it. And as well as having guidelines and regulations does not mean people will not adopt. Actually, if you have guidelines in place, they may encourage the adoption better and more organized. So specifically looking at Section 34, it's a provision in our Arbitration and Conciliation Act that provides for grounds on which an arbitral award can be set aside. If you look at that provision closely, you realize that the grounds about inability of a party to present its case, procedural inconsistencies, issues to do with corruption, fraud, impartiality or lack of impartiality, then awards that are against public policy. So basically that section is specific to specific things that the law is looking at, and mindful that this section was made or the act was passed and commenced way before we have this debate of AI and its use in our jurisdiction. So when you look at that law, yes, there could be provisions. For instance, if you are having issues on misuse of AI, that you could rely on. Now, for example, Section 34(2)(a), I think part 3, where you have a situation, if I may paint a picture for our audience, if you have a situation where an arbitrator has relied on AI and they did not disclose, while you're reading the award, you discover that there is a point across the arbitrator and they have made a finding on it. The same position you would have in our civil procedure rules, where you have a judicial officer come up with the issues, but those issues have not been put to the parties to submit. Maybe after you have done your scheduling, court now goes into the determination and comes up with a completely new issue that none of the parties had the opportunity to address the judge on. So the same arbitration where an arbitrator used an AI tool, that AI tool generated an issue and it was resolved in a particular way, and the parties didn't actually put that issue across. Maybe the issue discussed something that the parties had opted to leave out. So you could come under Section 34(2)(a), Part 3, which talks about its conclusion, the inability of the party to act without engaging us. We have lost that opportunity to address you on that. And just like Dr. Chunda said, you could also further it and say, we did not even give you permission to use AI. So how would you use it in the first place? So it's possible to come under that. So, and then issues to do with parties' consent, because now that section would come into question whether it can protect party autonomy, where a party has not given their consent with the use of AI, and the arbitrator should rely on AI reasoning to do that. So basically, that section is specific. Now, we may need an extensive regulatory regime that covers other aspects of AI that you cannot simply push through that section to challenge an award. And basically the mindset shouldn't be that in regulating AI, we should come under a section that is largely designed to set aside awards, because it would look like we are trying to stifle the use of AI by codifying Section 34 to contain an extension of AI regulation. I would think that we may look at coming up with a dedicated legal regime, which could involve probably an act, and most importantly, regulations that could time and time again be revised and amended to make sure they move with the changes in AI. As we speak today, someone is coming up with a better version of those AI tools that we have been speaking about: ChatGPT, Gemini, Legora, Harvey. So every time we are trying to play catch up, we are not actually moving at the same pace. So that's why we need to rethink and have our regulation revised time and time again, because even the institutions worldwide that have come up with these rules are revising them. Some of them are, after 2 years, become ineffective. They cannot continue to serve the purpose for which they were set out to serve. So if you are to come up with a regulation or guidelines around AI, I think there are four core principles that the person coming up with these guidelines should think about. The first I would recommend should be the use of AI in arbitral proceedings. Is it permissible? You need to have that guide. Is it allowed? Can the parties agree to use AI and in terms of the proceedings, the institutional rules, and other directions? Can we rely on AI for us to get that? Dr. Junda spoke about the red fund schedule and what you can use it for in preparing and presenting your evidence and disclosure. So can we now take counsel out of that and leave it to the tool? And that is critical for us to think about. And then issues to do with delegation of responsibility. So as you're coming up with these rules, you need to think about that an arbitrator must not delegate his or her adjudication function. They should retain the ability to decide the matter if the parties have come from them. But then that question is broad. What have I retained in deciding a matter before me when my analysis, my summaries have been done by AI? So what happens in a situation where I am appearing to be giving a decision, but my process has been tainted with AI at every junction and at every stage? So it is important for us to know that as we speak about the arbitrator not delegating their adjudicative function, adjudication or determination in deciding, but the summary you read to come to that conclusion was done by AI, and it left out something that could have led you to think differently had you personally paid attention to it through substantive disclosure. And this we have been mentioning throughout the process. The rules need to be clear on what disclosure means. We understand disclosure in arbitration, but when it comes to AI, how far-reaching should the disclosure be? Should I give the entire thread of my engagement with a tool from the point I told it to look at the document to the responses that I gave to it after? Because if you have used AI, you realize that the more you prompt it, the more the answer can change or be different. So when I'm disclosing, do I only stop at telling parties, I used AI, end of story? Or do I go to the point of showing the parties, if I'm the arbitrator, what responses I was receiving every time I engaged AI? Because you could ask the question, change it a bit, and it will give you a different response. Then the most important aspect of those guidelines, as we are coming up with all the principles we can follow to come up with the guidelines, is that how the award can be set aside where there are cases of AI misuses, because we do not want to create a notion that every time someone uses AI, you should simply run to the courts and set aside the decision because they applied AI somehow. There are some AI tools that may not actually play a big factor in the decision. Someone is using Grammarly, someone can argue Grammarly is AI, another will say, no, it's not. But it helps you in proofreading your work and what you're saying. Sometimes no, it doesn't. So we need to also have that guide around that. So Victor, to just circle back to your question, it focused mainly on section 34, and I have addressed what section 34 is about. But for me, the takeaway from that question is that do we need to revisit our laws such that we make ourselves ready and contemporary in addressing issues around AI in both arbitration and other dispute resolution mechanisms? The answer is yes, we should actually. We should not just play catch up. In Uganda, we take a while to change things and play by the trends. For AI, we need to act faster. Why? Because by the time you pass that legislation, if it takes a whole year, what you were dealing with, the mischief you tried to cure at the start of that year has changed. So we need to do actually much better in this space to be able to address the challenges. Thank you very much.
Thank you, Mr. Semaganda. I think we've exhaustively discussed the theme, and I think we are going to entertain some questions from the participants. And it will go this way. Someone may raise a hand and they will be asked to ask the question, or you can type the question in the chat and I'll be able to read it out to our speakers today. It can be specific to a speaker or it can be a general one. Participants?
I can see there are some comments in the chat. I don't know if you're able to see them. I've seen someone called Coyote F Adenji.
Yes, something just to look at the comments. Mr. Coyote F says, there is now arbitrate.com promising to declutter the courts in Africa using a Rev AI to draft contracts and arbitration documents and award, but there has to be humans involved. His comment is, we must not subject ourselves to machines. Humans must be involved. He also mentions, or his comment is, AI simply reduces the necessary labor of coming up with initial drafts. A revisit of our ACA is expedient. Maybe let me go to, there's a question from Mujisha Jean Cloud. The comment, thank you. Mine is a supplementation. I have built an arbitration AI model called Arbit AI. I would wish to share how it works. Maybe, Mujisha, is it possible to just drop a link in the comments? Whoever needs to see how it works will be able to look at the link, and I think they should be able to follow it. Thank you. Any questions? Any other questions or comments? Norbert Akaye, isn't there a possibility that use of AI will create a defect in legal reasoning in ADR? Any of the speakers who wants to pick up that question?
Victor, I can address that question. Now, yes, it is possible that if humans or lawyers decide to largely rely on the reasoning of AI, it could affect the quality of the decision. However, what is important for us to know is that we should avoid delegating every function of our responsibility to these tools. If you understand AI from the mindset that it is a tool that you're supposed to use to make yourself more efficient and better, not to allow it replace you, yes, it should be able to give you that benefit and avoid diminishing the quality of the reasoning we expect from a judicial or arbitral process. So what is important for us to understand is that it's not enough to just say we shouldn't use AI. What is important is for us to know how do we use AI. And right now we should have a holistic review even of how we learn. I happen to have been in London in June for a training that also partly focused on this subject of discussion. And what the universities there are doing, they're actually doing a curriculum review to include the use of AI or studying the use of AI, even in law school. How do you use AI responsibly? So much of the discussion in many of the circles is that we shouldn't. It's bad. It's going to affect this. It's not efficient. And we largely rely on the cases which have faulted the use of AI. And it's true, in many of these cases, the judges have arrived at the right decision by faulting the lawyers that have irresponsibly used AI. However, that is not enough. What is important for us to learn how do we use it and in what cases can it be relevant? For instance, there's a tool that I've used of recent to instruct it to draft a pleading. And I was surprised that it was able to do it to a certain level. Yes, after its draft, because for purposes of this very session, I deliberately gave it pleadings. I gave it the plaint, I gave it the defense, and told it to draft a reply to the WSD. Now, I withheld, because this is a matter that is already in court, I withheld the reply to the WSD, but didn't give it that. We had already finished. Now, when it gave its result, the result was closely similar to what we had actually filed in court. Now, I had a question at the back of my mind. Has it somehow accessed the court system and saw what we actually put there? Or it is coming up with this information on its own. So it's true that sometimes when we heavily rely on these tools, they can affect the quality of reasoning by giving you a result that is not premised on so many other aspects, because in deciding disputes, it's not just the looking at the documents you're presented, but there are also other things that you factor in as a human being to arrive at the decision. So the simple answer is not necessarily. It depends on how the AI has been used and for what purpose.
All right, thank you so much, Mr. Semaganda. There is a comment from Alan Muliowa: garbage in, garbage out is a golden formula in ICT. Dr. Chirunda, would you mind do you agree with them, especially considering prompts, how you prompt AI?
Yeah, thank you very much, Victor. And I do agree with I wouldn't put it as bluntly as that, but the logic is exactly what I agree with. Mr. Mlio has nailed something. You know, one of the biggest risks. So I'm going to build on that to touch on something else. So first is you only get out of the tools what you put in them. But second is how you use the tools really, really determines the quality of what you get out of them. There is this major concern in terms of are these tools making us dumber? There's an article I would recommend to anyone who's interested in reading about this space. Around 2005, gosh, that's 20 years ago, someone published a paper that asked the question, is Google making us stupid? Because at the time, the craze was the internet and the fact that you could Google anything. In fact, that's when the discussion around the word Google becoming a verb came up. Because if you're in the US and you ask someone, how do I get this? I say, Google it. So to Google is now a verb. At the time, there were concerns about whether Google was making us stupid. It's the same thing here. We're now saying, are these AI tools, when we rely on them too much? So the first risk is garbage in, garbage out. What if I don't put in any garbage? The question is, if I type a shallow inquiry, will I get? If you just go and say, I have a case against the plaintiff, draft for me a pleading. There's so much you've left out in that prompt. Any of us here who've litigated, you know that first case is signing, second case signing, third case, with your drafting, you're probably thinking about the statute under which the other party is going to oppose. So you start writing wording to answer what you expect the objection to be. The AI tool won't do that unless you ask it. Now, you could ask it and it will give you the pleading that resolves the issue, but if you don't, it won't. So I agree with somebody or other. In the end, you only get out of these tools as much juice as you know how to squeeze out of them. So it is worth learning how to use the tools correctly. Thank you.
All right, thank you, Dr. Chirunda. Just a question from the comments addressed to you. Dr. Chirunda, could the use of AI gradually change what we consider to be the reasonable arbitrator, particularly where failing to use available AI tools might itself eventually be viewed as inefficient or negligent, maybe with the continued and widespread use of AI in the future? I think the question here is, could the use of AI gradually change what we consider to be a reasonable arbitrator?
So the short answer to that is it will depend. And I know that sounds like an evasive answer, but let me explain. It will depend on how jurisdictions, whether they choose to regulate or not. If jurisdictions leave the question of regulation where it is today, then it may not matter much. If we go the way that Mr. Samaganda proposed, which is we vary the law to address the various issues that arise, then inevitably the grounds for setting aside will go into a reasonableness test. You see, right now, there is this thing on public policy, which is the catch-all. It is wide and yet narrow. That public policy is undefined, so anything that offends sense of sensibility could become public policy. You see, or what's that other famous ground for setting aside? My favorite wording from Justice Muguri is shocks the conscience of the court. There are people who have had hearts and they're not easily shocked. So what shocks your conscience might not shock them, if you see what I mean. But I will suggest something else instead. That if you ask me to make a prediction about where we will be in 5-10 years, I think automated arbitration will increase, and therefore I think the test will not be so much what Mr. Okello has in mind in terms of a reasonable arbitrator. I think the test will be different. It will be in terms of whether this was comprehensive, whether it considered all the grounds, or whether we will start to measure the quality of the award arithmetically. You know, for instance, in copyright and patent infringement, how do you know if my software is different from yours? You see, if you use lawyers as an example, a plaint is 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 a plaint. We all know the template in our heads that paragraph 1 is the plaintiff and address. Paragraph 1 has the plaintiff, their name, their address. Paragraph 2 has, and that address is the address of the lawyer. Paragraph 2 has the defendant and their address, and we presume them to be of sound mind. And we will serve them. Paragraph 3 has the cause of action. Now, there are some lawyers who will take the cause of action, who will take the reliefs and put them in paragraph 3. I think it's the wrong way to draft, but that's not what we're here for. Paragraph 4 is grounds for cause of action. Paragraph 5, injury. Paragraph 6, all of us know those 8 paragraphs, and they're all just enforcing one decision. Auto garage and motocov. What is the cause of action? The defendant had the right, the plaintiff infringed it, there was injury. So we have that framework from the day we started legal practice, or we left ALDC, right? Now, whether the plaintiff has the cause of action, the answer is well known. But in copyright, a lot of, now we can debate the quality of the plaint depending on, Mr. Semaganda's plaint will obviously be better than mine, because for him, he's specialized and he's sharper and he's experienced, but those are considerations that don't determine the baseline. In copyright infringement, a lot of software will be similar. Almost a good number of websites are built on WordPress, so they will look alike in some ways. That doesn't pass the infringement threshold. The law doesn't define the infringement threshold. So one way to do that is if you overlay the layers of code, how much code goes from here to here. And in America, for instance, they have a percentage beyond this threshold, you copy it. So I think that's where we will go in 5 to 10 years' time. We will say, could a reasonable arbiter will be that who passes a certain threshold. And if the award doesn't pass that threshold, also because the tools will have become too cheap and too good that all the things we worry about today, they will be able to do. Hallucination isn't as bad today as it was 2 years ago. Hallucination in AI 2 years ago was such a massive problem. And I think that hallucination will be resolved by the end of next year. My estimation is that tools by the end of next year won't be hallucinating. Now, that will not be the problem. So it means that the fairness standard in an award or the accuracy standard, new standards will emerge that are beyond reasonableness, because your reasonableness is subjective. And the test is some curious but nosy bystander looking inward. Now we're going to replace those with measurable ways to say, yes, this tool considered everything or it didn't consider. I think that's where we are going. But we wait to see. I hope depending on where you stand, I hope I am right or wrong. We'll see.
All right, thank you. Just maybe we take 2 last questions which have come in through the comments, and then we close. So Rachel Tafumba asks, the ability of AI to take out cognitive bias that's inherent in humans is ideally looked at as a plus. However, how do we balance the capacity of the AI with the fact that its training is based off human opinions and writing? Dr. Chirunda?
See, I told you that model had hidden the unmute function. So Mr. Fumba raises a really critical question. The ability of AI to take out cognitive bias that's inherent in humans is ideally looked at as a plus. However, how do we balance this capacity of the AI with the fact that its training is based off human opinions and writing? That's Rachel, that's a really interesting and complex question. I think it depends on the context in which you ask the question. If the context you're asking the question is, should we be celebrating something that is in fact potentially entrenching biases, then definitely there's a problem there. If you're looking at it from the perspective of, no, cognitive bias can be good because it has context and nuance. In the AI space, nuance is just as important as context, and they are not the same thing. Then you're dead on the money. There's something to worry about there. If, on the other hand, you take it from the perspective of, we want to be able to remove any biases that could be bad that come from a person, then the answer there would be different. So your question just invites more questions from me. Are you looking at cognitive bias as purely a good thing, which we should protect, and AI is damaging? Are you accounting for the fact that sometimes cognitive bias is bad, and therefore we need to be guarding against it? Are you looking at the problem that you're dealing with in that context of AI as, think about medicine. The use of AI in medicine is such an interesting question, because we just need to treat. If what I want to do is remove the appendix in the fastest way possible, I have a very specific problem. There's an appendix, I need to cut it out. I need to do it in 30 seconds and not cause bleeding. And the variables there are defined. But once you get into cognitive bias and the way humans think, and you start, the only correct answer I can give you is it really depends on your framework of analysis. What are you considering a good thing and a bad thing? In whose context? Because what is good for educated people might not be good for people who didn't have a chance to go to school. They are not stupid because they are illiterate. No, no, no. So what is intelligence? And then we go down a rabbit hole. And that is one of the biggest debates around the philosophy of AI. So I suspect I'm sounding vague, but the only answer I have for you, Rachel, is it depends. Are you looking at bias as a good thing or a bad thing? Do you want to preserve it or do you want to eliminate it? Because it could be either. are you solving a defined problem? Are you solving an undefined problem? Only when I have those variables can I give you my thoughts on that. Perhaps Simon could want to weigh in on that.
Yeah, Doctor, I agree with most of the observations you've made. In the interest of time, I'll leave it at that. I would have added much on that, but I agree with them.
Maybe Simon, before you let it go, there's a question which has come in, which I think you may be able to answer from Lutalo Abdul Hafiz. The comment is, we are not using AI enough. We need simple guidelines from various arbitral institutions. And he would like to pick your minds on those two issues.
Okay, I thank you, Victor, and thank you, Mr. Utaro, for the question. Yes, in Uganda, I haven't done much analysis to know the numbers. Yes, we are not using AI enough. But like I said, that I was in London in June, and I noticed that in many of the firms, the top firms in arbitration, many of them are using AI, especially when it comes to what they call the simple tasks. That would ideally take a lot of your time reviewing documents, drafting pleadings. But what they are doing is that they are not detaching themselves from the process. They are still involved. Yes, they can instruct a tool to do certain things, but they are still involved in reviewing and approving before these documents go out there. Because, like we have seen, in many of the institutional rules, you still remain responsible as the arbitrator. You still remain responsible as the counsel for the outcome generated using AI. So when you say that in Uganda, we are not using AI enough, if I'm to limit it to Uganda, since Mr. Otaro seems to be coming from Uganda, the answer could be yes. But you need to have some numbers to back up that answer. Now, when you say we are not using it enough, the question is going to be, we are not using it enough for what? If it's for arbitration, probably, but we need to first of all understand what are we supposed to use it for. Yes, there are lawyers and also arbitrators who have not been able to appreciate to the extent what can you delegate to AI to do what probably should do yourself. Now, when you use some of these tools, you start to appreciate that there are certain things they make you very effective about. One of the things I note mostly is that after I've drafted let me say a contract, I can pass it through an AI tool for purposes of identifying the conflicting provisions I have in the document. And I have discovered that these tools are very good at that. Numbering problems. They're very good at identifying that you have numbered one clause 7.2 and there's another clause within the same contract is still 7.2, and you can correct some of these issues. They are tasks. Sometimes they go to the extent of proposing which provision should you have maybe considered. And then you can go ahead to consider it yourself before implementing it. So that is different from entirely telling a tool to draft a contract for someone without looking at it. So we should be probably using it in terms of making ourselves more effective, better, and responsive. Because it's very bad for counsel to submit a document to a client that is having a lot of grammatical errors, having a lot of provisions that do not speak to each other. And then you could have used these tools to make you better. We all know that the more you look at a document, the more you generate proofreading bias. Some of the errors, you can't see them because this document has been in your face the whole day. But if you gave it to someone else or to that tool, it can be better. On the issue of guidelines, yes, even in this very discussion, we have identified that we need guidelines because once we leave it open without clear guidelines, as Dr. Chuna pointed out, sometimes it stifles adoption. People will be caught in between. Does the court or does the arbitration process allow me to use this tool to come up with the submissions for, if I may put it like that? But if the guidelines are clear, what I can do using AI, then it makes the adoption easy. In response to Mr. Otaro, maybe that could be a good solution, that the guidelines are going to give you the pathway on how you can use AI in that process. And also the issue of disclosure. It's very critical. When people are using these systems, they need to also be open about it and especially if you're in the decision-making space, let the parties know. But at the top of every discussion around the use of AI, the first step is always to know which AI tool am I using, what does it do when I give it this information, and how does it arrive at that output. There are tools that basically you could give all the documents you want them to look at and restrict them to only look at those documents and give you a response. You could even prompt them further to take you to the very area of the page where they are picking that information, and you double check yourself. Then there are tools that if you leave them or structure your prompts to be open, they can go on the World Wide Web and pick whatever responses they can and give to you. So you need to first of all understand, how am I going to interface and interact with this tool before you even just say, let me just use AI. So that's what I can respond to Mr. Otaro and to the question in general. Thank you.
Thank you so much, Mr. Semaganda. To our participants at CEB, we have very many events just like this one that was brought to you today. And we also have very many other events that are lined up. And so you should be able to check the chat right now to see the various events that we have lined up for the next few months in the calendar. And Mr. Semaganda and Dr. Chirunda, thank you so much for being speakers today. And I would just want you to give your parting shots. Dr. Chirunda, your parting shots in a minute or two. And Mr. Simon Semaganda, your parting shots in a minute or two. Thank you.
So, first of all, I am grateful to every single participant who's been with us and who stayed with us all the way to the end. I'm grateful to SIAB for putting this together. I'm grateful to Mr. Maganda for such deep insights, reflective, deep insights based on actual personal experience, and to yourself, Victor, for hosting and moderating. My parting shot on this would be simple. If you are participating in an arbitration, either as counsel or as an advocate, you need to pay enough attention to the use of AI. It is not going away. And not just by the fact that you need to learn to use it well, to use it correctly, but also because you must be able to anticipate its pitfalls, just in case the other side uses it the wrong way, or the arbitrator. You need to be able to pick up what the other party gets wrong. To do that, you must be good and proficient at what you're doing. But also remember that at the end of the day, these are tools that are here to just help us. And I think I saw a comment from Mr. Renaito Patson, which is a comment is worth highlighting. These are tools that are only meant to assist us, not to do the work for us. They are evolving, and where AI is today isn't where it was 2 years ago. Where it is today isn't where it will be a year from now. It is worth staying up to, keeping abreast with what the changes are and how they'll affect your practice. I thank you very much and wish you.
Mr. Semaganda, just your parting shots.
Thank you very much, Victor. I also would like to thank SIAB, Uganda chapter, as well as CLET for putting this together, as well as Dr. Chirunda for sharing the very detailed insights and experience he has given in this session. Thank you very much. Now, for the participants that have joined us today, we want to thank you for attending. My takeaway for you and in closing this session is that we should understand artificial intelligence to be a tool that can assist us. If you're an arbitrator, it can assist the arbitrator, but it should never become the arbitrator. It can assist counsel, but it shouldn't assume your role and professional responsibility. So that means that we should start to change our perception and how we look at AI, become better in our work if we allow it to be in that space, rather than giving it a space of replacing our own abilities. Thank you very much.
All right. Thank you so much, speakers, and thank you so much, SIAB, for organizing this. Dear participants, once again, our events lineup has been shared in the chat. you can go there and see the events that might interest you, that you might take part in as you know, till the end of the year. Thank you so much, and we'll be closing the webinar at this moment.